Yep. Okay, yeah, there's that. I will consent to be recorded. All right.
Let me make the vote.
Perfect. Okay, yep, awesome. All right, thank you, Melissa, and thank you all for those who are here in person. Thanks everyone who's gotten on online. And so for those of you who don't know me, I think most of y'all do at this point, but I'm Nic Lovelace. I am our Knipp Law office's managing attorney for both our Concord and Kannapolis offices, including a nice little convenient office about its 15-second walk from the room in which I am presenting here at the Lantern office. So I really appreciate getting the participation and the knowledge, because I mean this is something that it's important to know about. There's a lot of misconceptions about how it's such a simple thing, but there are a lot of misconceptions on how DD, EMD, and terminations work. And I want to clear some stuff up, go over some best practices, and just go over some details about what, I mean, because unfortunately, not every transaction is going to close. That's why they have those forms. And so just kind of go through some details as to how you can best handle them when they come, because you're going to find that there are a lot of folks out there who don't really know the best way to terminate a contract, don't really necessarily know how to appropriately terminate a contract. There are probably a lot of real estate contracts that have been in progress for the last 10, 15 years because people don't know how to terminate real estate contracts because they don't terminate on their own, despite what others may tell you. So what we're going to do, what I always do, and I'm going to go ahead and share my screen now so y'all can stop having to look at me online. One sec. So we should have that screen shared now. So this is, like I said, due diligence, earnest money, and terminations. If for whatever reason someone on Zoom is not seeing my screen, please let me know so I can address it. Otherwise, I'll go ahead and move on to the first slide. So let's see if I can work this. There we go. All right, so I always start with some helpful definitions. So basically, these are just the definitions related to the topic that we're working on today. First off, your due diligence, everyone pretty much knows what this is, although we don't know how much it is these days. Due diligence is your fee that's payable directly to your seller upon the seller's acceptance of a buyer's offer that's considered non-refundable, except in cases of seller breach, and we'll talk about that a little more here in a bit. Your due diligence period is the period of time given to a buyer to conduct due diligence as specified on Section 4 of the contract on the property as spelled out in that contract. Your earnest money deposit is a deposit held by a third party in trust to be applied to the purchase price. That is considered refundable until the expiration of the due diligence period. Again, there are some very specific circumstances in which earnest money is non-refundable, and we'll talk about that here in a bit, even prior to the expiration of the due diligence period, even though it would cause some issues. It would only be caused by some issues on the termination side, or the breach side, really. Your escrow agent. So that is the person who holds the earnest money deposit until closing. Typically, it's the closing attorney. On occasion, it can also be the real estate brokerage. I know Lantern does not favor holding EMD. Y'all are happy for the closing attorney to hold it. I think that makes the most sense. It's the easiest way to do it. There are some other states where the expectation is that the brokerage holds it. North Carolina does give you that option, and we don't have a problem if you want to, if for whatever reason, let's say you're on the listing side of a transaction, if you're dealing with an agent, with a buyer's agent who wants their firm to hold the money, not a problem. That's a doable thing. That shouldn't be a deal breaker, game stopper, whatever. Settlement. That is the process of signing all documents and sending all funds to the settlement agent, closing attorney, whatever you want to call us. So settlement is when we actually sit down and everyone's like, oh yeah, let's go to closing. You're actually going to settlement. You're not going to closing. Closing is the process of completing settlement, signing all the documents, us doing our title update, getting the deed and deed of trust recorded, and having all the money sent out too. So the closing is actually the entire step, the entire process from signature to sellers get their money. buyers get their keys, and that is closing. So when everyone's like, oh yeah, we're excited to go to closing, you're actually going to settlement, but don't be that person that's like, leave that to me. All right. And termination. Termination is the affirmative process by which one must cancel the contract due to the non-performance or the other, or due to their rights in the contract. This can be mutual or unilateral. In your unilateral termination, one person terminates the contract by either their legal right or when the other party breaches the contract in some way. We'll talk about some of those ways here in a bit. Then your mutual termination is when both parties agree to terminate the contract as a result of the circumstances of the transaction. See those pretty frequently. Honestly, we see more mutual terminations than we do unilateral terminations. They're not always used correctly, but we do tend to see more of your mutual termination documents. Does anyone have any questions about any of the definitions here, comments? Awesome. So we'll go ahead and move on to next slide, which is basically your delivery of due diligence. So when is due diligence due? It is, legally speaking, due to the seller at the effectiveness of the contract. Once the seller accepts the buyer's offer, delivery of due diligence is pretty much supposed to happen right then. Now, typically speaking, I mean, obviously you have to have some sort of reasonable period by which the seller can receive those funds from the buyer. But per the contract, upon effectiveness, upon signing, send the DD ASAP. Now, DD can be delivered. We don't care. Honestly, I mean, we do care, but you know, we're not going to monitor or really pay specific attention to whom or how due diligence is delivered. As long as page 15 is signed. So, I mean, if your client wants to Venmo, send Bitcoin, send a fruit basket, and the seller says, yep, I consider this 500, I consider this enough to satisfy due diligence, we're not going to say anything. Lender might not like it, and that's probably going to be a little more important. They may very much care how due diligence is delivered. They might very much care to whom due diligence is delivered. So they're probably going to want to see you write a check or something of that nature to deliver due diligence to the seller. But I mean, realistically speaking, from our standpoint, we're not really going to want to be involved with due diligence money in any way. That money is supposed to be given directly from the buyer to the seller. It's not really supposed to go through our office. We're not, I mean, we've been in situations where we've been asked to hold it for a couple hours, and while it's not really something we favor doing, it's something that we have done in the past just because it's most convenient. The easier way to do it, you just tell your seller or buyer, hey, put a check in the mail to the seller, or give it to me. I'll take it over to the seller's agent. I mean, there are plenty of ways to do it that do not involve the attorney's office. Now, what I always tell folks, and this is a very important deal for me. We see a lot of folks get buyer's remorse. You've got a buyer who signs the contract, like hours later, they're like, oh gosh, I really didn't want to pay that much, or I really didn't like that house. I'm just not going to write the due diligence check. Well, here in the era of $5,000, $10,000, $25,000 due diligence fees, that's a pretty considerable expense, especially when you're looking at, it could be an EMD is $2,000, $3,000, $4,000 in connection with that. So a lot of people aren't going to want to write that check. Now, I usually say, hey, you got an accepted contract, that due diligence is due no matter what. So if you're on the list side and you run into that situation, your client is due that due diligence, even if the buyer says, you know what, I don't want this house. I'm just not going to write a check. As soon as your seller accepts the buyer's offer, due diligence is due, regardless of whether they reach out hours later and buyer says, you know what, I know you accepted my offer. I want to cancel the contract and not send you due diligence. If you can do it, I mean, you can definitely say, you know what, that's okay. I get it. We'll move on to another offer. But I would suggest you definitely let your seller know that they're entitled to that due diligence fee. And if the buyer doesn't deliver the due diligence fee, then that's a breach of the contract. And with a breach of the contract, per the remedy section they're also liable to lose earnest money. So if you don't send your due diligence, even if you're before the end of the due diligence period, you can still be liable for earnest money because that's a breach of the contract. So that buyer's remorse move could actually cost your buyer additional money. If they were to go to court, it's pretty open and shut. I mean, it's pretty clearly spelled out in the contract. You don't send due diligence, it's a breach. You breach, you're responsible for both earnest money and due diligence. So just additional money that they'd be out of pocket. If due diligence is not received, seller must give notice in writing for the contract. So let's say a day, 2 passes, seller doesn't receive earnest money and they're ticked off. They're mad at you, they're mad at me, they're mad at the world because they haven't got their money. They need to give notice in writing and email sufficient to say, I'm requesting due diligence. I've not received the due diligence. I'm requesting the due diligence. Same thing with earnest money. But we're not really going to hold it. We're obviously going to want it, but we're not really as serious about that because we know folks are going to deliver the earnest money. We are serious about it, But buyer has one banking day to deliver the due diligence to the seller. If they don't do that, then seller can say, yep, that's a breach, I'm going to terminate the contract. Yeah, sure.
Sometimes they have addendum, but they say they're gonna deliver it, let's say a week after.
Yeah, you can definitely do that.
And one question: is it a good practice to not to change the MLS status before you receive the due diligence? I mean,
I think my understanding of that is once you've accepted the contract, you need to accept it because you've got a ratified contract once you've accepted an offer. So once you've accepted an offer, you have to move it up into.
Even if you communicate, for example, in an email saying, look, I'm not gonna change the status until I receive the due diligence.
Chris just sent that out today.
Yeah.
And we went over it this morning.
Mhm.
You have to.
Yeah, you have to.
Yeah.
You have
to go to the MLS and put it on.
Yeah, it's required to be updated because even though the due diligence hasn't been delivered, you still have a ratified contract and an accepted offer as soon as the seller accepts the offer and signs. At that point, you're pending. You're no longer on the market. You now have a pending contract.
Because it happened a lot, let's say, with investors that they take their time to send the due diligence. And sometimes you're there wondering, will they send it or not? And then if you change the status to, let's say, that under contract, then you kind of losing other potential buyers that might offer you in case those investors back off.
Well, and that's why folks might not necessarily want to rush when they get offers in. As soon as let's say you accept that offer, you might be expecting more than you think it more coming in. You not necessarily want to rush, and that's what investors will do. Is a lot of investors will say this offer is only good until X date. Well, if you're concerned about that about the integrity of that investor or the investor's ability to deliver earnest money at a reasonable time, then I mean it's not a bad idea to see what other offers come in and give a little more time and let your clients know that. Let your clients know that there's probably that this is an investor offer. They may be a little slower to deliver some of these things because that's in your experience, and see what they say based upon what you relate to.
And there is a form for that bottom line for the notice in writing. We were talking about that this morning.
Form
335, 355 or 335.
I had 355.
Okay. One of them's a unilateral right to terminate, and the other one, yeah. So just
So
a
you
lot
can
of people weren't aware of that this morning when we were talking about that. There's an official form.
Yeah, so you can use that form, but like I said, email will also suffice.
I would also suggest get tracking information when you send a check. I had one last year that the broker asked you to send it to the seller directly because he was on vacation and it was just going to Mooresville.
Yeah.
6 months later, the
Oh,
check
gosh.
finally showed up. I mean,
Wow. Yep.
they were literally calling me on a Sunday going, we don't have that tomorrow.
Mhm.
And I had to get, my client to write another check and
Yeah.
handle it.
Yeah. And there are other methods of doing it. I mean, and they're all spelled out on the contract. Like I said, if your client wants to send Bitcoin or cryptocurrency or something like that, and the seller is willing to accept that, you can do that. As long as they sign on the bottom line, or Venmo, we're starting to see that more and more. Like, you just got a lender involved. Make sure you verify with your lender that they are also going to be okay with that method of delivery. Any other questions on the delivery of due diligence? Trying to move to the delivery of EMD. Now, while we don't really care how earnest money is delivered, we very much care how and where your earnest money is delivered if we're the escrow. And this is also due to the attorney upon the effective date, unless there's a box that you can select, which gives you an additional 5 days in which to extend that time period. I would advise folks, I mean, there's no reason, if you're on the buy side, there's no reason not to check that box. Because why would you, I mean, if you can give your buyer an additional 5 days, most folks on the listing side don't really even look for it. They're just going to look at the number. They're not really going to care about what's over to the right. So give your client an extra, just a little bit of wiggle room on that. I mean, obviously you want them to send it as soon as they can, but you can check that box and extend that time period. Most attorneys' offices, ours included, are not going to want either cash or an electronic transfer of funds. And when I say an electronic transfer of funds, I'm not talking about an ACH. I'm not talking about a remote check deposit. I'm not talking, when I say that, I'm talking about an ACH, not a remote check deposit, not a wire. We'll accept a wire. We've got a program that will accept, we've got an app that we work with where you can remotely deposit a check. But we're not set up to take ACH payments. Most attorneys' trust accounts are not going to be set up to be able to take ACH payments because they can be reversed on the sender's end. So the way our account's set up, if an ACH payment is sent, it will automatically reject it and send it back. And so I think, and my understanding is most attorneys' EMD accounts are going to be similar because they have to comply with state bar rules, accounting rules, trust rules, everything like that. So I've got your 3 best ways to pay. Either a personal or certified check made out to the attorney's office, a wire to the attorney's trust account. For our firm, you can use the Zaken app to deposit and check electronically. You fail to deliver earnest money, that is a breach of the contract. And as the attorney, even though we are representation for the buyer in terms of delivering title, everything like that, we are required to maintain a neutral status as to the disposition of earnest money. So with respect to earnest money, you have to stay neutral. And we also can't, if we're asked by the seller, hey, have you received earnest money? And we haven't, we are permitted and advised to notify the sellers that we haven't received. That was a recent addition to the contract approximately 2 years ago. And so now that they've updated that, because there were some situations where the attorney's office or the escrow agent hadn't received the EMD, but they felt that they weren't allowed to tell the sellers because they're representing the sellers. So you get to closing, earnest money still hasn't been delivered to the attorney. That's a breach of the contract that the seller didn't know about, but the attorney felt like it was a conflict if they told the seller that they hadn't received the earnest money. So now there's that specific language in the contract that authorizes the attorney to notify all parties if the earnest money hasn't been. Any questions about that? This one's a little more simple because we're involved and we try to make it easy.
In what circumstances does the AMD come to the sale?
So yeah, the seller, you mean when does
When can the seller
record-
keep it? I think there is a.
Basically, there's several circumstances. If there's a breach of the contract on the buyer's end, then the seller would retain the earnest money. If you get past the due diligence date and due diligence, if that expires, and then the buyer says, well, no, not buying it now, and there's no breach on the seller side, then the earnest money's already become non-refundable at that point, and it would go to the seller's. Mike?
Yeah, this is based, I'm licensed in Massachusetts, so
Mhm.
I'm just, a question kind of based on that. Now in
Mhm.
Massachusetts, if you go under contract
Mhm.
and then the contract is not completed and you return the earnest money.
Yeah.
If the buyer has decided that they are going to keep continuing to look for a property and
Mhm.
they're gonna buy something in the future.
Yeah.
The attorney or whoever's holding the money has the option of not returning the earnest money and leaving it in their account. So
Yep.
they don't have to write a check later.
We can do that as well. We've done that before.
Okay, that was gonna be my
Yeah, we'll
question.
just transfer the earnest money from the canceled file to the new file, as long as we're notified, hey, hold on to it, they're getting under contract and something else, that's not a problem. Any other questions about earnest money? All right, so we're gonna move on to the purpose of due diligence. So everyone pretty much knows this. It's pretty straightforward, so I'm not gonna spend too much time on it. But the due diligence purpose is your conduction of inspections of the property, securing financing. More important for your investors, reviewing zoning and HOA access, everything like that. Because a lot of these companies have now put in your HOA rent caps, things of that nature. So, and you're actually going to see with a lot of offers from investors, they're going to ask sellers to provide those HOAs and or HOA and CCRs, bylaws, everything like that, to make sure that there are no rent caps on the property, or to allow them to terminate and retain all their money if they do. If you have a contingent sale, technically speaking, per the contract, and a lot of people don't necessarily adhere to that, but part of the purpose of due diligence is to make sure that the sale not only is pending, but is completed. So if you've got a contingent sale and it really does have to be contingent, you might want to consider having an extremely long due diligence period. I don't know how realistic that is in today's market, but that's technically a purpose of due diligence as well. Negotiating of repairs, y'all know all about that. Or if you are not satisfied with the condition of the property, you can submit that unilateral termination. The 350T is for your contract with improvements. 351T is your unilateral termination for vacant land. And then a buyer, according to the contract, may continue to investigate the property following the expiration of the due diligence period. I do receive a lot of negativity in terms of, and that's where I see a lot of folks kind of get a little buyer and seller anger towards one another, is where the buyer wants to continue their inspections. The seller said, you know what, your due diligence period's over. We're not letting you back on the property to conduct inspections. Per the contract, seller is supposed to allow the buyer to continue to be able to conduct those inspections. They just can't get the earnest money back after. So if you are in a situation where you represent a buyer and the list agent is saying, no, their due diligence period's over, they can't do anything more on the property until their walkthrough, that is not true. The contract does specify they can continue to investigate. Any questions on that?
Can Lantern take part of the earnest money?
Yes, they can, but that's more spelled out. It depends. Like if are you talking about the list on the listing agreement?
No,
Yeah. So
if they terminate
yeah, I mean, technically
and the money
speaking,
goes to the seller, can Lantern take part of that money?
technically speaking, I mean, it would be spelled out in terms of whatever your fee would be, and so the listing agreement does permit that. It's just a matter of personal preference as to whether you want to continue to work with that seller.
Right.
But if they've driven you your wits end and you're going to fire them anyway, then hey. All right. Any other questions about this? All right. So as you approach the expiration of due diligence, what are your options? Well, there's always your classic, I'm going to send you an extension or a termination and a due diligence repair request. Sign the one you want to sign. And I don't know about this market, you want to do that? Although we're edging there, we're getting closer there. But right now, you can always send if you're not satisfied with conditions of the property quite yet, you got another inspection you want to do, you can always either extend due diligence or terminate and offer those two options to the seller. Got your 310T, your due diligence repair request form. I mean, obviously, everyone knows that that's the form you can use to request those repairs from the seller. 5 p.m. means 5 p.m. So if you're coming up to the end of the due diligence day, you hit 5 o'clock, it's 4:58. You want to send this termination and make sure you retain your earnest money. All you have to do is click the button and make sure it's sent by 5 o'clock. It's not when the seller receives the termination. It's not when the seller receives the request for an extension. It's when the sender clicks the button saying it's sent. So if you can show on your computer that you sent it at 4:58, even if they were in a bad service zone and didn't receive it until 5:04, that's still considered a timely unilateral termination. Now, you can also conduct inspections after due diligence with reasonable access under the contract. I was just talking about that. A lot of times the results of the survey are not going to come in until after due diligence. Surveys, what are those, right? If the survey result comes in after due diligence, then if they come in bad and it looks like there's a marketable or insurable title issue, you can still the buyer can still terminate the contract because that's considered a title issue and retain both earnest money and due diligence. Now, these days, you got your appraisal done, everything like that. I'm going to stay far away from discussing those today, but your results of the appraisal are also going to come in after due diligence. If you feel like you need the results of that appraisal to come back, you're going to want to extend. Just because if you need it to hit, otherwise you got to terminate. I mean, extend it, explain that, hey, we're waiting on the appraisal. It might work, might not. It is what it is. But I mean, yes.
No, you go, you first. How about the 7 days that we have? Extra 7 days. I mean, you don't have to send it by 5 p.m. if you had a
The 7 days only applies to that doesn't apply to due diligence. That doesn't apply to the due diligence period. That only applies to the closing.
Yeah. Okay.
I was just gonna ask.
Nick,
If they could share, what is the length of time people are putting on contracts now? I mean, from what I understand, it's just arbitrary kind of 5 or 6 weeks, and then you want to be, I'm asking, that, you look shocked like that was ridiculous. Tell me, I don't know, that's what I'm asking.
I just did some land 7 days. Closing
I
10.
still like to take care of my people.
Yeah.
So I do like a 21 day from the execution or the contract being executed. That gives me time for inspections and the appraisal to be back.
21 days, guys?
As long as you're working with the right lender, yes.
Yes.
It depends on how bad they want the house. and
Yeah,
I mean,
if
that's what
they
I'm
If you're doing
So
cash, you could say
competitive.
no.
I
Yeah,
can- I can
really.
get a home inspection done and results in 2 days.
I can too.
What
I-
can keep finding people
Yeah.
not having the vendors?
Normally,
I use Crossroads.
normally 3 weeks is what I put, but if someone's gonna close quicker, I mean, I've gone as few as 5 days, 7 days. and, Normally a 28 day.
Okay.
The longest thing is the survey, if they want a survey.
If they want a
Surveys are
survey, put
8
about
weeks.
four months on that.
It's 8 weeks.
Yeah, it's pretty wild.
So by taking care of your people, 21 days would do that for like
Yeah.
the most
I
important.
mean, if
things.
I've got somebody that just doesn't care and
Yeah.
wants the house, they're not gonna have inspections for the part of using it during due diligence.
Mhm.
They're just doing it for their own information, then shorter is fine.
Yeah, then the lawyers, you have to do all
What
this.
if it's a cash
Yeah.
offer too?
Yeah,
What did you say?
Cash.
If it's a cash offer, I go
Yes.
2 weeks.
Okay.
but you still wanna go through it, have
Yeah.
enough time for them to walk through with the
Okay.
home
Sometimes
With an
inspector,
inspector.
just for your peace of mind.
It's like you said, depend, because sometimes the seller demand
Yeah.
shorter time, you know?
Mhm.
So more competitive offer
Mhm.
is
Yeah,
shorter.
the shorter the
Shorter,
offer, the more
okay.
competitive it's gonna be. If
Okay.
you're submitting 5-6 week offers, those are gonna be more challenging.
And it also depends, I think, too, how much due diligence. I mean, I have a
Money, like
client
the
that I
money,
was-
the amount, you mean?
Yeah, that he wanted this house really bad, and we, I mean, we were $20,000 above asking price. Asking was 210, we were at 230, and he did 20,000 in due diligence and another 10,000 in earnest money. Want us out bad.
Then he may not do it.
You know,
And
Yeah.
honestly,
So he
in
may
his
as well
case-
just put that money down in those categories. It's all gonna come out at some point.
Yeah, I could have closed him in 2 weeks, but I mean, I had a home inspector, who's a fellow that I use that, you know, he can go out and do a pre-inspection for you too.
Oh, okay.
But,
Maybe not
I mean,
quite as thorough, but. the-
yeah, we made the offer on a Sunday, and I mean, I had a home inspector.
Would you guys find you sometime?
Nick, I have a quick question whenever.
Yeah, sure.
before you leave
Go
off
ahead.
This topic. Do you know if, and this may be a question for the specific sellers, the
Yeah.
estate attorney, but do you know if the court has approved the sale
Uh-huh,
of real property out of the estate?
yep.
And then let's say there's a change to the contract. Does it have to be resubmitted to the clerk of court again to approve that minor change, which could possibly be an extension of the due diligence period?
It depends on what the change would be. If it comes from the clerk of court's office, it would depend on whether it's quote unquote a material change to the terms of the contract. Generally speaking, what sort of change are you talking about?
Well, the only potential I'm seeing at this point, because we just went under contract today. I just got the court
Mhm.
order approval back today, showed it, got the administrator of the estate to sign off
Mhm.
on the contract, notified the
Yep.
buyer agent, changed it in the MLS. But I'm
Mhm.
thinking that it's potentially they're gonna be asking for the due diligence period to be extended. I mean,
Yeah.
that's the only thing I can see right now possibly coming forward.
Generally speaking, a lot of orders are going to give some discretion in terms of whether they want to. With respect to due diligence, I don't necessarily think that they'll require additional court approval. But it's definitely a question I would ask to there should be an attorney involved with the sale.
Yeah.
I would ask that attorney whether they would require any sort of update. A lot of times there's a commissioner involved. I would talk to the commissioner and see, because most of them should be able to just drop a quick update and send it over to the clerk pretty quickly for them to see if it needs to be approved.
Okay, that's kind of what I was thinking, but I didn't know if there was, something kind of set in stone that you would say,
Yeah,
oh, no,
there's-
any change at all has to go through the court again, and so. but
Yeah,
I would-
mostly the court's concerned about closing date, closing costs, or closing date, purchase price, and the expenses with the agents, but that's really all they really are concerned with.
Okay, thank you.
Yep. All right. Anything else on the expiration of due diligence? All right.
Just one more question.
Yeah, sure.
Is it mandatory that, you will ask for it, but how about if they don't want to
Don't want to accept
to
what?
extend it? If we did it in period.
Well, if they don't want to
It's
extend,
not mandatory.
yeah, if your clients don't want to accept the due diligence period, they don't have to. And so that's what often will happen is folks will send, here's a due diligence extension, here's a termination. You're not willing to extend the due diligence period, we're going to terminate you.
But you send them at the same time.
Yep, I've seen them send at the same time, and you sign the one you want. Like I said, these days, I don't necessarily know it's quite as much of a threat as it has been in the past, but you certainly can do it. Yeah. All right, so after the due diligence expiration, that's when your earnest money becomes hard or non-refundable. Doesn't relieve the seller of their requirement to deliver good title. Still got to do that. That's still a big part of what they're doing. So if a survey reveals an uninsurable issue or something else comes up during the course of title that causes it to be uninsurable, buyer can still terminate. Buyer can still, like I said, retain that earnest. They can have the earnest money released to them, and they would also be entitled to the refund of due diligence from the seller. Appraisal results do not matter unless you have an addendum saying differently. That's as far as an appraisal addendum as I'm getting today. And a buyer can still try to mutually terminate or basically just not go to closing, knowing that they're going to lose their earnest money and due diligence if they can't show a seller breach. So basically what that is you see these mutual terminations that get signed after the expiration of due diligence, just because for whatever reason, the buyer can no longer purchase. So the reason for doing that is if you're a seller, you think, no, why would I terminate this contract? I really want to sell this house. Well, you've got a buyer who's already passed their due diligence date. So they've really got nothing that they still have hanging over the seller at this point. The earnest money's sunk, due diligence is sunk. They've got no grounds except for they can just say, you know what? All right, if I'm not going to buy this house, I'm just going to sit on it until 7 days after closing. And technically speaking, they can do that. I mean, the seller can say, well, you didn't have grounds to do that. But then you go back to the buyer. What's the buyer out? Well, if there's a breach in the contract, buyer's out, earnest money and due diligence. So the seller can't really terminate the contract. I mean, they can try to unilaterally terminate it and say that the seller is not delaying in good faith. But there are really specific points on that document. It's the 352T, the 353T, where the seller can unilaterally terminate. And there's nothing on there that says buyer isn't acting like they're going to buy the house. I mean, there's just nothing on there saying it. So it would be difficult for a seller to unilaterally terminate for a breach that they think is going to come from the buyer. So that's why you see a lot of those mutual terminations due after the due diligence period, because the seller has an incentive to make sure that the contract is terminated earlier so they can relist the property. Buyers obviously got the incentive to mutually terminate, and they can address release of earnest money.
And how do you address the release of earnest money if the buyer terminates under due diligence but the seller?
If the seller refuses to sign the form, we are not authorized to take one side or the other party's side. So if the seller refuses to sign the form, from our legal analysis of it is we are not authorized to release it, because the seller could claim that at some point during the due diligence period that the buyer breached the contract. So if we were to release it, we would not be holding our standard as an escrow rate. And so we would be liable. So then that's when we have to start the earnest money dispute process.
I was gonna say, at that point, when do you turn the money over to the clerk?
So it takes, we have to notify, first we verify with all parties that there is a dispute, that buyer's not budging, seller's not budging. Then we have to hold the money for 90 days and before we can release it to the clerk. Then at that point, you've got a neutral fact finder who determines which side is someone who's actually supposed to do that work to determine, okay, you're supposed to get the money. You're supposed to get the money after hearing that.
Does it happen often?
We probably deal with probably 10 to 12 of them a year. Fair enough. We have pretty good volume. Any other questions on this? All right, so your terminations 101. My first one, and I've heard other opinions on this. I think it is very clear in the contract that all terminations require an affirmative act. So if you want to terminate a contract, it doesn't just happen. The term, if you wait 7 days after the closing date and don't send a termination in and have it as a seller or as a buyer and terminate the contract, you still have a valid contract. All the language in the contract says after 7 days, the non-delaying party may terminate the contract. It doesn't say after 7 days the contract is terminated. That's me being Mr. Lawyer here, but that is a very important distinction, because let's say you get to day 10 and you've still got a buyer who wants to buy and you've still got a seller who wants to sell. Do you have to re-execute? Has anybody had to ever re-execute a contract? No, because that contract is still in force. I've heard some other opinions on that. Those opinions are, I don't even say they're just factually inaccurate. You do have to send in a termination to terminate a contract. It sounds a little, I mean, it sounds silly when you say it, but hearing the other opinions, you do have to do that. And so all documentation says, like I said, a contract may be terminated by one party. The seller can unilaterally terminate as a result of the buyer's breach. That can always happen. The buyer can unilaterally terminate during the due diligence period, and that is specified, or they can terminate as a result of seller breach. And as we discussed, the parties can mutually terminate at any time during the contract with or without release of EMD. So let's say you've got a seller who wants to get their property back on the market. You've got a buyer who wants to get out from under contract so they can buy something else, but they're still mad at each other and they still want to fight over the earnest money. They can do that. You don't have to release EMD in order to terminate. Any questions? Right, let's see if I can, here we go. So your seller unilateral terminations, these are forms 352T and 353T. Once the seller is under contract, the seller's right to terminate the contract is extremely limited. You're under contract, the buyer's under contract to buy your house. Theoretically speaking, there is no other house in the world like the one that you are selling to the buyer. There is no other 123 anywhere street. That's the only house in the world that buyer wants to buy. That's why a buyer can go, and if there's a breach on the seller side, the buyer can sue for specific performance. We'll get into that here in a little bit. But in order for the seller to do unilateral termination, the buyer must breach the contract in some way. Typically, it's due to the buyer's delay, a lot of times due to a lender, or a lot of times due to a title issue, something like that. But the seller cannot, one thing the seller can't do, and I've seen sellers try to do this before. The seller, let's say they want to terminate, they decided that we don't want to sell the house or we didn't like the deal we got. So we're just going to withhold information. We're going to withhold the information the attorney needs to get for the payoff. We're going to withhold something that the buyer, like information for the HOA or something like that. And then claim that the buyer breached the contract when it didn't close on time. That is not permissible per the contract, because per the contract, the seller needs to provide certain things in order for the contract to be completed on time. So that would be characterized as a seller breach, not a buyer breach. Now, and like we were talking about, even if the buyer does breach, the escrow agent will still need the release of the escrow funds to release the funds to the seller. Otherwise, we go through that EMD dispute process. Any questions? All right. Now your buyer unilateral terminations, your 350, that should say 350, sorry, that's a typo, my bad. 350T and 351T. You use that when you terminate during the due diligence period. Use that when you terminate as a result of your seller breach. That is, again, potentially due to the seller being able to deliver good title. That's usually what it is. That's almost always what we see when the buyer terminates unilaterally, at least after the expiration of the due diligence period. Before the hand, it's almost always that they just didn't like the results of the due diligence. Oftentimes, you get results of a survey that aren't positive. Again, even if the buyer breaches, seller breaches, sorry, another typo. Escrow agent needs to release of earnest escrow funds to release it. Otherwise, the dispute process will be required. Same thing as the other one, is just flipped around.
This is the case that when you lose that money, or that due diligence, no matter what amount, if the buyer terminates.
So if the buyer terminates, well, that's where you lose earnest money no matter what, if they terminate during the due diligence period or after the due diligence.
They don't lose their due diligence.
I mean, your due diligence is, yeah, basically I always treat it, if you submit a contract, your due diligence is pretty much non-refundable unless the seller breaches the contract. So. All right, mutual terminations, and these are the 390T. That's correctly identified, and the 391T. These can happen at any time. Like I said, typically happens after due diligence. And it's when the buyer and seller don't want to wait for a breach to terminate the contract. And you can release the earnest money, that's your 390T, or initiate the EMD dispute process, that's your 391T, where the attorney holds on, or escrow agent holds on to the earnest money deposit. Oftentimes, you know it's going to terminate, so the grounds for a breach aren't there, and I should say aren't there yet, because they will be after that expiration of the delay period. Seller wants to put the house on the market, buyer wants to resume house hunting, then they can mutually terminate the contract. Everyone goes their merry way, and everyone can buy and sell as they want to do. And you just use the form based upon whether the parties agree or not. Agree, 390, disagree, 391, move on down the road. Everyone's relatively happy. Mutual means everyone's agreed on it, so sometimes mutual means everyone's mutually dissatisfied, but hey, it's what it is. Any questions about that? That's super straightforward. All right, EMD disputes. So this is what Mike and I were talking about a few minutes ago. For an EMD dispute, you do need confirmation from both parties that there is an irreconcilable dispute at the time. If it's determined that there is an irreconcilable dispute, say that 5 times fast, then we'll confirm with everybody and we'll notify both parties. We have to send a letter out to everybody. It has to be a mailed letter that we have to hold the earnest money for 90 days before we can release it to the clerk of court. 90 days theoretically gives the parties time to try and work out a solution, work out, hey, you get X, you get Y, or gives them time to lawyer up. After 90 days, the attorney sends funds to the clerk of court. Clerk of court notifies all parties that they now have the money. Come fight for it. The clerk of court, then after a year, the money will just be escheated to the court or escheated to the state. So if you don't do anything within a year, state gets your money. So make sure you use that and let folks know that if they want to fight over this earnest money, say, make sure that you really want to do this, because you're going to have to hire an attorney, you're going to have to battle it out. And if it doesn't go your way, you have to pay attorney's fees for the seller. And if you choose not, or for the opposing party, and if you choose not to do it, then you can either you can always execute a release to the other party, or state can get your money. So, and then you can, if parties don't want to wait the 90 days, and we've actually had this happen also, one party can take the other party to small claims court, get a judgment against them in small claims court, present us with a judgment, and we have to release the money. We can do that before we send it to the court. But again, someone has to really want that money and take that affirmative step, taking the other other folks to court. Any questions on that dispute process? That's all.
How if only one of the party appears in the court?
Then the court will issue a default. They'll basically say, well, other party didn't care enough to show up, so this side wins. Any questions about the EMD dispute process, which is always fun? All right, your due diligence dispute. Sellers usually got the upper hand pretty well because they've got the money. So parties aren't going to always agree that they're in breach. So let's say a buyer wants their money back and says, seller, you breached the contract in some way. Seller not always going to say, oh yeah, you're right, I breached. No, sometimes they're going to say, no, I didn't. I breached the contract. I got your money. Come sue me. So if they don't agree, you can end up with that dispute about due diligence. Typically speaking, earnest money is also going to be wrapped up into that. And like I said, the seller's in your driver's position because they've already got the funds and you've already got really limited situations under which due diligence is refundable. So you're basically going to have to sue them. Buyer's going to have to sue the seller, get a judgment against the seller for the amount of the due diligence. Like I said, typically speaking, the earnest money is also wrapped up in that, but the losing party does pay for legal fees as well. So if you've got a seller who everyone knows has breached the contract, and they're just saying, you know what, I've got the money, come get it. Let's make sure they're aware. Well, if you get sued and you lose, not only you have to give the due diligence back, not only do you lose your earnest money, but now you got to pay the legal fees for the losing party as well. And if I were a buyer and someone made me sue them for a clear breach, you better believe that I'm also requesting all the expenses for anything that I've paid during the course of the transaction. And that's not even taken into account that there could be a situation where the buyer is just going to ask for specific points to buy the house. So if you've got a seller who has clearly breached the contract in some way, and they're just being stubborn, you might just, oh no, hey, you're going to lose. Even though you got the money, you're still going to lose quite a bit if you have a judgment. All right, and your termination best practices. So this is just from our standpoint, things that we don't always see that we would like to see. number one, if the contract is terminated, please let us know, let the lender know, let everybody know as soon as possible. Especially it's early on in the transaction, because the sooner you let us know, we can call and we can cancel a title search. The lender can cancel an appraisal. You're going to save, especially on the buyer's end, a lot of money by making sure you not tell everyone that there's termination. We've had a termination before where we got to the date of closing and nobody showed up. And someone called, that was a dual agent handling both sides. And dual agent just kind of forgot to tell us the transaction was closing or was terminated 3 weeks before. And so we charged both their clients, it was a closing fee on each side. And guess who had to pay? Make sure to let us know. Don't tell your clients to expect money back until you have confirmation from the other party that they're relinquishing money. So if you've got a client who says, all right, I'm terminating, this before the end of the due diligence period, I'm going to get my $5,000 earnest money back. Just correct them, so you'll get your $5,000 back once the seller signs to release the earnest money, to make sure they're aware that there is that additional step and that they don't automatically get that money. Legally, with a unilateral termination, the transaction is terminated once upon delivery. So if I'm a seller, or let's say I'm a seller and you're past 7 days and I send you your transactions terminated, that's great. Or transactions terminated. As soon as A gives B the termination, terminated. But until EMD release is signed by the buyer in that situation, EMD is not to be released in the legacy. You don't want to jump the gun on it. Make sure to identify how the party receiving earnest money wants the funds transferred. We get the termination document all the time with a release of earnest money saying, how does the seller want the earnest money? By check. Great. What am I supposed to do with the check? Just let us know. Similar to anytime someone's picking up a check, where do we send it? They're going to pick it up. Just let us know so we can avoid further calls and your further frustration. Anytime there's termination, there's already some frustration involved. So you want to make sure that you just kind of tie up all loose ends there.
Just
And
a
then,
procedural question.
Yeah.
Do the checks, say from your firm, do they come from your central processing office in Charlotte? Or if I'm hand delivering it back to my client, can I get a check?
you can get a check at any of our offices. Just ask which office they'd like it to come from. And we've got check printers at every single one of our offices. So we can print a check from any office that you want. And then the earlier you terminate, the more costs you can avoid on the buyer side of the transaction. Like I said at the beginning, if you know your buyer doesn't want the house, don't let them just ride the transaction out. It's better to just get it over with so they can go do their other things. But that's it. I think that's all I got. Does anybody have any further questions or anything about what we've talked about? I know it's not the most exciting topic when you start it, and then you're like, oh gosh, yeah, I run into that, I've run into that. And there are a lot of things you don't necessarily think about terminations. But yeah, if anybody has any questions, please ask them.
Sometimes people have questions over seller terminating or seller breaching and what their responsibility is to the buyer.
Yeah.
As far as fees, buyers have already paid into the transaction for inspections, attorney fees, etc. So
per the contract, the seller is required if the seller breaches, and the buyer can request that the seller pays their inspection fee, all their fees associated with inspecting the property. Now, again, if the seller says, you know what, screw you, I'm not paying it, then that's where the buyer would have to file suit. But if they're filing suit for due diligence, probably going to file suit for that. They're going to lump that too. So it's kind of, if they get to that point, then that's probably going to be something that's included, but it's not something that automatically comes, but because again, that's a sunk cost on the buyer's side that they would have to seek from the seller, money that the seller has. I mean, they'd have to reach into their pocket and get it. It's not something that the seller would just necessarily have to. So for the contract, they'd be entitled to it, but it's a lot easier to say, yeah, you're entitled to the earnest money than it is to actually.
And as a listing agent, we want to make sure our sellers are aware of
Correct, yeah.
what it means if
Mhm.
they breach.
Yeah, if they breach. And one good thing that they did with the most recent contract is they put all of the breach information into that last contract or last paragraph. I think it's paragraph 23. It spells out all the remedies for a breach, for a seller breach, and the remedies for a buyer. So you can very easily point to that contract and say, all right, seller breaches, this is what could happen. Buyer breaches, this is. Any other questions or concerns? 3:58, that worked out pretty well. Awesome. Good timing.
Good job.
Awesome. If you have any questions, please feel free to let me know. I'm happy to send this. Thank you to all y'all who participated on Zoom. I hope y'all could hear me well enough. But I really appreciate y'all all, and we'll do this again soon.
Thank you, Nick.
You're welcome.
Thank you.